updated, expanded, and uncensored. It's the only book of its kind revealing the secret history of the last few hundred years, which documented the foundation of the Great Reset. Learn how the building blocks to forced vaccinations, a digital ID, a cashless society, and ultimately a social credit system that will deny you access to healthcare and even the money you have in your bank account were constructed hundreds of years ago and will, without your resistance, become a reality in your lifetime. Fight the future. Get your copy of The Synagogue of Satan, updated, expanded, and uncensored at moneytreepublishing.com.
You're listening to Speak Free Radio, the free speech internet radio platform.
Good evening, episode 2. I'm getting feedback. How do I kill that? Anyhow, this is Charles Lincoln, and I'm getting feedback. I don't know how to stop that. Dave, real quick. How do I stop the feedback? Can't hear you. Are you there?
Can you hear me?
I can hear you now.
Okay. Are you playing the show in the background at all?
Not that I'm aware of. Anyhow, okay, and now that you're on, the feedback is gone.
I don't know. What I'll do is I will exit the studio and listen to you and see how it sounds, okay?
Okay, Dave, all I can say is thank you for making this possible. Thank you for inviting me to Speak Free Radio. This is a great platform and a great opportunity, and there is some feedback. It's just very faint right now.
Well, I'm going to exit. Thank you, Charles. I appreciate it. You have a great show yesterday, and I'm going to exit, and we'll listen to you on there. If anything comes up, I'll let you know.
Okay. Anyhow, check on YouTube, too. Anyhow, today we're going to do something a little bit different. Last time was kind of the continuance of a previous podcast that I used to have, and I had guests, and we talked very generally about social issues and social problems. But with this program, I really want to focus on the legal world and the specific crisis of the failed legal system. And the failed legal system is intimately related to, I guess you could say, my own failed professional life, except the way I like to explain it to people is my failed professional life as a licensed attorney was the beginning of my awareness and education of the truth about the world. Everybody needs a crisis to crystallize their consciousness and awareness. I don't see how, without going through the fire, you can ever understand what it means to be burned. You can never understand what other people are going through until you have been, in some sense, tested in combat. This is literally true of every soldier. It's why war games are so important to the preparation of an army. Why people practice boxing and fencing before they try to do it professionally. And the sad thing is that it was being disbarred, which is now for me 23, depending on the state you're talking about. It's either 21, 22, or 23 years ago. I was not actually a conscious human being while I was part of the system. Everyone who is part of the system is blind to the evils of the system. And Brian Kinter, I'm saying how I'm starting off by telling them that while I was part of the system, I was completely unconscious of the system. And while I was a member of the bar, I knew nothing about the realities of the bar or the corruption. I guess I had a few hints, but in general, you can't understand a system if you're part of it. Or at least it's very difficult. And I was saying that you have to be tested by fire. I think you've had a little bit of experience in that. And that's why I wanted you to be part of the show tonight. And why I think that your input is going to be particularly valuable tonight. You look like you've had a rough day, though. How you doing?
Hey, I'm surviving the storms alive, Charlie. And
I can't. Now you're very quiet. I can't hear you very well.
Can you hear me now?
A little bit better.
Charlie?
Yes.
Can you hear me now, Charlie?
Just barely. It's very bad sound.
Okay. Well, maybe I can try to get in on another device and see.
Well, can you just turn up the volume? See if you can turn up the volume.
Well, I got the volume all the way up on top.
Well, I think you maybe you just need to be closer because I could hear you a little bit better when you were getting closer.
Okay. Can you hear me now?
You're still kind of faint. I don't think it'll broadcast very well.
Okay.
Can you hear me okay?
I can hear you just fine.
All right. Okay. Well, anyhow, try. I'll keep talking, and you try to adjust.
Figure out what's going on. Yeah, I'll try to find out. I'm going to get Zach down. Okay.
Because I brought Brian on here. Well, for one thing, because he's such a beautiful guy. You can tell you just look at him. I mean, I need Brian here, because he's been a warrior for many years, and he's been fighting, and above all, he's been fighting for his family. He's been fighting for his family, and in particular, he's got a son who is in very big trouble, and his son is currently incarcerated in northern Illinois. I believe someplace called Winnebago.
Yes.
If I remember correctly.
Yes.
But he's being held by the state of Illinois as a proxy for the. Hello. Are you Zach?
Yes.
Hi, Zach. I'm Charlie. Good to meet you face to face. Now I can hear you a little bit better than I can hear Brian. What's going on? Can you talk?
Can you talk? See if you can hear you.
Zach.
Yeah.
Okay, maybe it's just your voice. I can hear you a lot better than I can hear Brian.
Okay, can you hear me any better now, Charlie?
A little bit. It's It's not really major broadcast worthy, but I hope we can have a conversation. Anyhow, what I wanted to say was that here Brian is. Um, he's a little bit of a real estate magnate over in Ohio, and um, his son, 25 years old. Is that your son is 25?
Yes, 25 this past February.
The word "yeah" was loud and clear.
Yeah.
Anyhow, uh, the the point is that Brian and I are conspiring to basically break into not to break into prison, but to break into the courts and to try to break Andrew out. Uh, the key thing that we need to understand is that the courts are stacked, a closed system stacked against the people. In particular, stacked against people who are not either lawyers or represented by lawyers. I have this unique experience of having been an insider. You might even say that I had an absolutely top-notch insider education as a lawyer. I have been licensed in 3 states of the union, Florida in order, California, Florida, and Texas. I ran into some major political enmity with a certain governor of Texas who shall remain nameless, except to mention that he later became president of the United States. He designated me a dangerous guy, and I opposed his policies. And in particular, I opposed his policies on police and civil rights. Civil rights for ordinary Americans, civil rights for people in their homes, people who are being attacked by the police in their homes. And that was in the city of Lago Vista, Texas. And that could be a topic all of itself. But about 5-6 years ago, I met this guy, Brian Kinter. And Brian Kinter started talking to me about a whole bunch of problems in his life, including the struggle that he had faced with his family law and his struggles against to have custody of his children. And he actually ended up, after a very long struggle, winning custody of his children. But I think that, now correct me if I'm wrong, Brian, but I think that your basic feeling is that the struggle that you had for the custody of your children damaged your children's lives in some almost irreparable ways. Is that true?
Oh, absolutely. I sit and I look back on how the court would malign themselves, never look at facts, never look at evidence, just look at mere conjectures, speculations, accusations, and innuendos, but never look at the facts and never follow the law, and then we had to take a drastic step. And I had a number of attorneys over a 7-year time, cost a small fortune, but I finally got to the point where as we went into the federal court, then when I had named Judge Lori Reisinger, the magistrate, the children's attorney, the guardian ad litem, all the parties in play with aiding and abetting in parental alienation. And I was saying it's irrelevant what I say. A court can only tell its record. But when the record clearly illuminates each and every single allegation that a party and then make a conscious choice to deny the truth, even when the truth is right in front of their face, that's a real systematic problem. And then, Charles, as you know, is that we went on up, got all the way to the U.S. Supreme Court. And on July 13th, 2012, the U.S. Supreme Court initiated Rule 28.8 that states that no pro se litigant can have their day in court, which to me, again, I think is an abomination. So we went with Leon Kozol and a number of others, and then Zenit Crenshaw took that case, kept fighting, kept going in, using this case to illuminate that our justice system is weaponized against the average American person because it requires economics. And as you clearly stated, you as a card-holding member of the bar, if you don't have money to pay the attorney, and there's no guarantee that the attorney is going to do what it is that you desire or even give you zealous representation, which I always thought was a prerequisite, but the court simply wants somebody to go through the emotions to give an appearance of justice without any evidence to substantiate that justice was ever served. And I think that that's just wrong.
Brian, I'd like to see if we can we get you to sit and stand still and just sort of look into the camera here, because right now I'm only seeing part of your face, and you keep moving around so that you're sort of
well, I'm holding. I was holding the phone up so that you could hear me better. Are you hearing me okay?
Yeah, hearing is okay right now.
Okay.
I'm definitely hearing you, but try to hold it still so that don't look like you're having a spaz attack or something. When we were kids, we always used to say, "Don't have a spaz attack." Well, don't even look like you're having a spaz attack. Anyhow, what you're talking about, Brian, the expectations of the court and the expectations of the lawyers and how lawyers are supposed to behave, that is precisely the origin of the title of this new podcast that I've started. I'm calling it Legal Realism, Politics and Ritual in Law. And part of the ritual, what I really mean by politics and ritual, is exactly what you're saying, that judges have an expectation that lawyers will only do certain things, that lawyers will only take certain positions, that lawyers will only say and advocate certain kinds of ritually cleared, pre-approved positions in a court, or in outside of court, or even in dealing with clients and advising them. Basically, what I see and what I'm most concerned with is that the legal system, which should be the ultimate refuge of the quest for truth, the struggle for truth, the purpose of the court should be to make sure that everyone who has an opinion and a perspective on the truth should be able to speak it. And yet the reality is that what the courts exist to do is to prevent people like you, like your son, and oddly enough, like me, a graduate of Harvard and the University of Chicago. It's designed to prevent us all from speaking and asserting our version of the truth. Now, a philosopher will tell you that the only way you can achieve truth is through discussion. That's why Socrates and Plato are so famous for their dialogues, because it was argument and the presentation of disagreements and contrary perspectives that the ancient Greeks in their philosophy believed was the key to truth. No person talking to himself in a closet would ever know the truth. It's only when you get multiple people putting multiple angles of light on a closet, or in Book 7 of Plato's Republic, in a cave, different torches bringing light into the cave, ultimately breaking down the roof of the cave and letting the sunshine in. That is the only way you know what is really inside a cave, is when you have sufficient illumination. And the courts really are a cave right now. The courts are a complete cave sealed off from the rest of the world. And what we see over and over and over again is that cave becomes a prison, just like in Plato's Book 7 of the Republic. And people like your son are dragged in to the cave, and the only reality that is permitted is the reality allowed by those who control access to the cave. And in the modern judiciary, it is the judges and the lawyers who control access to this cave. And what the reason you're here tonight is so that we can talk about the ways that we would like to break open this cave and bring light to your son, to your son's life, and potentially to the whole world about what the court is doing. And let me just comment right now that the biggest problem in your son's case, from a very practical standpoint, is he's been incarcerated for close to 3 years now without a single hearing on the charges against him. Not only no trial, but not a single hearing. He has had 2 attorneys representing himself, neither of whom have presented a single motion or attempted any kind of formal discovery at all. And I guess, have you ever heard of anything like this? Did you think that such a thing was possible in America, for someone to be held without trial or hearing for 3 years and 2 attorneys appear one after the other and doing absolutely nothing?
Charlie, I never heard about it until I got into it. Okay. Once as my son got hemmed up in this here, and whereas we had called into question the authenticity and the validity of this alleged accuser, and it was initiated by an FBI agent. And I just want to set the stage here for everyone so that they can fully grasp and understand that, in the United States of America, if a party is charged under 2251, Title 18, for alleged buying and selling of children, which my son never bought a child, never sold a child, never had any involvement with that. He was a young kid. He was at 19, 20 years of age, just went through a breakup. He was online talking stupid with some people allegedly, and then had arranged to make a meeting. Come to find out, it's an FBI agent. But the scary proposition of 2251 is that there is a presumption of damages. There doesn't even have to be a victim, but the government can create a victim, and then you have to pay restitution to a victim that doesn't even exist. And then when you dig into the case even further and you discover, wait a minute, there was never any grand jury 4-person signature on the indictment, and then after you've done your research, you find 28 other people or 28 other cases that this has happened to, and yet the court turns a blind eye to it, and they take a personal vendetta when somebody stands up and calls into question, how is this the United States of America that's supposed to be based upon facts, evidence, and truth? Well, that's just grand until you're asking the court for those very sentiments. You're asking them, how did you justify these charges? How do you justify this? And then to have a young man at 20 years of age end up being incarcerated, and then the court never have any history, never had a problem, nothing with no run-ins with the law, nothing like this, has 2 children, and then turn around and say that there is no condition or set of conditions that reasonably exist to ensure the safety of the community at large. I think it's an ambiguous ass dumb statement, because there's no assurances that a judge isn't going to be overwhelmed with the events of the day, come down off of the bench, go to the bar, get drunk, run over somebody. Does that present a clear or a potential danger to society? And I think that it's a slippery slope when we start incarcerating people predicated on what may have occurred rather than on what actually did occur.
Well, let's try to unpack that. I'm not sure that I think you got a little bit ahead of me. I was speaking in very general terms, and you all of a sudden got very specific. And so let me go back and try to sort of retrace the steps here. Your son is accused of exchanging the factual allegations against him from the FBI agent you mentioned are that he exchanged pornographic images and texts with someone known to us only as Minor A.
That's correct.
This person has no reality, real identity. I mean, real ID is supposedly a very important thing. We have to go through all sorts of hoops to identify ourselves in this country now. But
if we can, Charlie. Now, here's the problem with that is that as you read 2251, and the judge's position is that we have to protect the child. And I'm saying, what if there's not even a child at all? What if this is just a fabrication of the government to
okay? I was just going back. I was
Department of Justice.
I was going to go back to the FBI statement. All we have in the record is an FBI statement that says that this FBI agent somehow came into possession of he came into possession of a series of text messages between Andrew and some person that he identifies as Minor A. He says under oath that this is a true and correct transcript of it, but of course it's not recorded. It's not actually recorded. The recording is not made part of the record, and the identity of this alleged child victim, underage victim, I should say. It's not actually a child. It's a teenager.
If it is even, in fact, an individual, we don't even know that.
No, we don't. But I'm just saying the way it came into court was through the affidavit of an FBI agent, and of course, as you're saying, that not so much the judge, but actually the law on the books says that it's important to protect the identity of a child victim, except from what we can tell, if there was a Minor A, she was really flirting, is the most polite way of putting it. She was very aggressively flirting with your son and offering herself as a romantic interest to him. And what's incredible is that this is something that not hundreds, not thousands, but millions of people of not just tender age, but all ages are doing in the world today. We all know this. And so the amazing thing is that in this incredible hypocritical world that has come into existence, your son has been prosecuted basically for flirting, and he's effectively facing a death penalty for flirting with sexual overtones with someone under the age of 18.
Well, he's looking at 15 years to life. And it's a minimum mandatory of 15
You're almost too silent to hear. I can barely hear you right.
I say, he's looking at 15 years to life, and 15 years is a minimum mandatory that's required under 2251. Now, one of the problems that I have there, Charles, is the fact that in the state of Illinois, if you're 13 years of age, you're a female, and you want to go and you want to have a sex change, you don't need to consult with your parents. You don't need to go and get a judge's permission. You can just simply go down and you can get a sex change. So a child at 13 years of age can explore their own sexual identity, going to the point of mutilation and alteration. But yet a 16-year-old girl, if she wants to express her sexual interest or sexual desires, and she flaunts her vagina out on the internet or images of a vagina, if in fact there is a minor A, okay,
it's worth pointing out that there are no images available to Andrew or anyone else. It's basically all based on faith. We are asked, and this is where the ritual points in. The law requires us to have faith in the FBI, in the judge, in the prosecutor, that there really was an exchange like this. The reason it's credible is, I guess, what I was just saying. We read in the media about what's something called sexting, that teenagers are used to sexting each other, using their smartphones to send pictures and highly suggestive texts that by email, text, and on various social media. And so the law creates the politics of the law creates a ritual presumption and a truth that we are asked to accept, and that Andrew, your son, and you, his father, are forbidden to inquire about. This is what's fascinating about this, is that this is basically a loophole big enough to drive not just a semi truck, but an interstate highway of interstate trucks through in the law. There was this concept ever since the trial of Sir Walter Raleigh in the early 17th century. There was this concept in the Anglo American legal system that every person has the right to confront his accusers. Now, what's the relationship between the family court that you were originally facing and the charges against Andrew? One way of looking at it is that in both the family courts and in this criminal prosecution of your son, the best interests of children is a mantra that is ritually invoked and used over and over again to suppress every other constitutional right. And that's part of my history, by the way. That's part of my history. My relationship with my son, my divorce and custody battle was all about a judge in Texas asserting that he had the right to deprive me and my son of our freedom of speech to say anything about our lives or living situation. That was really how I came into this. As it happened, I came into this mostly out after I was already disbarred, but that was the basis of my education, which began when I was disbarred, was learning how the family courts use this phrase, best interests of children, as a means of overriding freedom of speech, the right to confront witnesses, the ability to cross-examine the evidence against you, even know the evidence against you. And that is a very substantive and substantial connection between, the family courts and the criminal courts in your case. Your son is being deprived of any semblance of due process in the name of protecting a minor child who may not we can only speculate whether she exists or not. What you know, and what we could even presume if we didn't know, is that Andrew is a male heterosexual who uses the facilities of interstate commerce to flirt with women.
Well, and the other thing, Charlie, that we know is that The court system by design, I think, does more damages to the family unit than it does benefits. If you look at our case in our child custody case, my argument is that how can a judge deny one parent access to their children while enlarging the other parent's access to the children, absence of finding of unfitness, abuse, or neglect, and not be in direct violation of the Equal Protection Clause of the Constitution? If me and their mother had these children were a gift from God. They are our responsibility. You can't give her 90% of the time and me 10% of the time just so that you can get more money generated through Title IV funding. And that's a whole nother realm. But then you go in further and you look at just like in Andrew's case, he has 2 children of his own that he hasn't seen in 3 years. And I'm saying the breakdown of the family unit is diabolical by the court. And I can validate that and I can verify that by the Department of Justice's own statistics through the Innocence Project, Amnesty International, wrongful conviction. In the cases that do get overturned, 54% of them, they have found prosecutorial abuse or judicial neglect. And I'm saying, so you get it wrong more than you get it right. And those people, only if the entities such as the wrongful convicted or Amnesty International, they have a select group that they try to follow through. And that's only on the people that they can represent because there's so much money involved. It's a racket. And I've always said that our court system, the first order of business for the court is to make business for the court. How do we do that? We postpone it, we prolong it, we delay it, we deter it, we muddy the waters so that we don't have to deal with the truth or the facts. We have to figure out how we can make money off of it. And that's exactly my position with the court system. And there's no resemblance of justice when you look at the facts and the evidence that they are alleging against Andrew because they don't want to bring none forward. And here you have 3 years sitting and waiting to go to trial. And it's a constant, well, let's just throw you in. And the longer that you sit, the more probability and possibility that you're going to cop a plea. So they beat you into submission because the family is exploited financially, trying to hire an attorney that goes through the motions, but doesn't really get into the substance of what the crucial of the problem is. And I think we can all draw the conclusion that even with President Trump and what he's illuminated is that even department heads of the FBI have been known to give false and misleading testimony. And we have that in this case here with Michael Barker, with some of the things that he said in court that's not validated by the court's own record. And it's like, how do you speak ignorance and then once as it's written, just as it was in my case, there was an allegation of abuse. So there's an automatic assumption that that abuse had occurred when in fact it never did. And yet the deprivation has already occurred. And so it's just another hit in the wallet so that the court can continually turn you out until you finally come to the conclusion that you cannot get justice in the United States of America. And I think that Zena Crenshaw's pleadings before the United Nations in 2019 clearly illuminated that when they stopped short by acknowledging that in the United States of America there is no justice when faced with judicial corruption and judicial abuse. And I'm saying, where do we go for a remedy of relief if those that are supposed to deliver justice make an arbitrary election of choice to even allow you the opportunity to present the evidence that solidifies that this is bogus. This is absolute nonsense. Where do you go, Charles?
Well, I don't want to get into my disagreements with Zena Crenshaw, the late Zena Crenshaw, at the moment about the disadvantages of bringing in international law into the United States. I don't actually think that would help, but that's really not germane to our topic right now. There's several things, though, that you mentioned that we need to go back over. And one thing that you haven't mentioned yet that I do want you to mention on this audience, but you mentioned Michael Barker. Michael Barker is the FBI agent who filed this ghost, I would call it ghostly set of allegations that Andrew exchanged pornographic images with an unknown and by law unknowable young lady known as Minor A. The whole concept that this can happen without any sort of examination of direct evidence is a major violation of the Fifth Amendment. But I just want to say that part of the purpose of us having this conversation tonight is to announce that you and I are planning, and I hope we will soon be able to carry out, a direct attack on the indictment of your son on the grounds of abuse of the Constitution and the constitutional rights. And we believe that we have to act independently of the structures that are available to us through attorney representation. You and I both agree that and plan on launching an attack in civil court against these laws that basically have imprisoned your son based on unproved, not merely unproved, but based on the information available to us, unprovable allegations. And indeed, you mentioned that they are trying to extort a plea out of your son by threatening him, in essence, with life in prison. The minimum may be 15, but he's been threatened with 30. He's 25. That would mean 50 feet. He might get out at 55. Might get out at 52 with good behavior. And in light of other things going on in his life, it's effectively a life sentence. It's effectively the end of your son's life based on the flimsiest of allegations. I could write a story about you. I could write a story about anybody, and it would have just as much substance as and demonstrable substance as Michael Barker's allegations. And
okay, one of the things, Charles, that I'd like to add in here, and I can understand your concept and things, but the terminology. I'm not out to attack anybody. I'm out to defend my son's right to have his case being open and transparent. And I'm saying, wait a minute. Here we have the court saying that my son, that there's no condition or set of conditions that reasonably exist to ensure the safety of the community at large, but yet they don't want to tell the people what the allegations are, number one. Number two is that, why the hell, if you're truly wanting to protect the society, why is this case not being open and transparent for everybody to see? So I'm not out to attack anybody. I want to make sure of that. But I am out to give zealous representation and assistance to my son. I am not a practicing attorney. My objective to work with Charles Lincoln is to try to perfect the law as to this statute and the unconstitutionality that allows thousands upon thousands of men to be ran through the system just so that the court can turn out a profit. And that's what we are. We're nothing more than mere chattel that the state utilizes or the federal government utilizes to subsidize all of their programs. And I think this is just an abomination.
Well, okay, several points. The word attack is a term of art in law. If we file a separate lawsuit or series of lawsuits, it's going to be what's called a collateral attack on the indictment of Andrew Bolts. And that is the phrase. We have to be aggressive. We have to be plaintiffs. We have to demand rights because that is a legal attack. But anyhow, that's one. The other point is you said that Andrew's appointed attorneys have been going through the motions. I think you give them too much credit. I think you give them much too credit when you say they've been going through motions, because they have not filed even a single motion.
Right. Let me rephrase that, Charlie. What I mean by the motions, they've been going through the theatrics. They've been putting on the stage. They've been giving the appearance that, oh, well, here we have Andrew Bolts. We're his attorney. We've been in, just like Andrew's attorney now, Mr. Butler, Clarence Butler, goes in and he tells the judge, I've had the opportunity to speak extensively with my client, and I was rejoicing when my son said, what are you talking about? You know, you haven't even given me 5 minutes. You know, how the hell do you sit there and make a statement that you've talked with him extensively, and yet my son say, no, just 5 minutes before we had the hearing, and his attorney sitting there saying, well, Andrew, you just listen to me and stuff. And I say, Andrew, you are your own best defense. You must take a stand, and when they say something that's not accurate, you must object. And if your attorney don't, you have to, because this is your life. And they want to attach a tether to you that's going to affect the rest of your life and future generations if you don't take a stand to stop this proliferation of abuse from occurring.
I mean, it's fascinating. You say that Andrew is his own best defense. Brian, if I tell you that you've been doing business with aliens, by which I mean people from outer space, if I tell you that you've betrayed the United States and been selling out the United States to aliens, how are you going to defend yourself against that charge?
I'm going to laugh at it. I'm going to laugh at it.
You're in jail. You're in jail. I've sworn out an affidavit saying that you're committing treason, and that you're in league with the Martian League. You've joined the Martian League, and let's imagine my name is Michael Barker, and I'm in the FBI, and I swear that I heard you making deals with Martians. How are you going if you don't have subpoena power to bring the Martians into court and show that you weren't talking to them? How are you going to defend yourself?
Well, I would first go back, and I would have to say I thought that in the United States of America, it's not based off of conjecture, speculation, innuendos, and outright lies. Okay. Now,
all right, but I mean, how is if I accuse you of dealing with Martians, how is that any different from Andrew's situation?
Well, I think it's the same ignorance. I mean, you can sit there and make all the allegations in the world, but I would sit there and say, prove it. I mean, don't just say this crap. Give me something that shows that I've been talking with these Martians. Do you have communications with them, or are you on a terrestrial plane or something? I have no idea. All I know is, so when I say that Andrew is his own best defense, I say this, Andrew, I wasn't there. Charles Lincoln wasn't there. No one else was there. Only you was there, Andrew. You know what you know. And if you know that what you know is opposite of what somebody else is saying, you have to present that. But there's other people, such as your father, such as Charles Lincoln, such as a number of others that are coming alongside of you saying, we will help you to gain a voice to be able to do this, and we will try to get as much educational material for you and try to get these things called into question, because I think that you are a young man that may or may not have even had this conversation. We don't even know, because the government has withheld that. They won't even allow Andrew to look at the discovery. And then if he is granted the right to discovery, it has to be at the prosecuting attorney's office. And like Andrew said, is that, Dad, I have no idea. You go in there and they put a picture in there with no face, and it's a picture of a vagina. Can you tell me with absolute certainty that this was the vagina that was shown to me back on X date or this date, and does it belong to minor A, which we don't even know who the hell minor A is. So how do I know that you didn't just grab this image off of the internet, which is filled with schmuck, and then just put it out there in order to draw my son into this hellacious nightmare so that you could extort him to accept a plea so that you can continually drive up revenue for the court? And that's my honest belief.
Well, here's an interesting point. We've been so far just talking about Andrew, but have you noticed? I know that you've been obviously studying the question of 2251, 2252 of the United States Code, Criminal Code, and you've looked at a bunch of other cases. What are some of the patterns that you've seen in the nature of the nature and identity of the people who've been charged with this crime?
Well, number one is that, and I want to bring that up. Number one is that it's the FBI or the government that's bringing forth the charges, bringing forth the claim. It's not a victim, whereas that victim has been identified. The common denominator is that the victim is never identified. And then when we take and we look at what the Department of Justice's own statistics will validate and verify, that the vast majority of children that are engaged in illicit activity such as prostitution or underage sexting and things like that are products of CPS, Child Protection Services, what should be called Child Predator Services, because they go in and they take and they malign the children to believe that they have all of this rights, that rights, all of this other stuff, and then they take and they want to promote all of this independence and their right to do these things. And then when they do, they come out and they cripple them, and just the children, and just as you and I, we're nothing but mere chattel. That's what we are. We're chattel that the court excuses for their own folly and their own gain. There's no resemblance of truth and justice, in my opinion, in the United States of America if these cases cannot be open and transparent and call into question all of the other aspects. You look at what I was on the phone the other day with a lady down in Florida who is a psychologist, and they're saying, my God, your son's being accused of being this monster, but yet he's been locked up for 3 years and they've done absolutely nothing to try to get any type of evaluation on your son. Doesn't that seem odd? And it just finally dawned on me, you're absolutely right. Why? And the law says they have to use the least restrictive means for incarceration, and yet here my son, just predicated off of an allegation, can spend 3 years and nothing being done about it, just time wasted.
I guess I also wanted you to point out, I know we've debated whether to make this a civil rights issue or not, but you have noticed that there's certain let's call them demographic patterns in the prosecution of people. What is the typical profile of a person who's in your son's position?
According to the Department of Justice, and I think it's over 90%. It's like 94.6% or 96.4%. Those people are white American males between 18 and 45 years of age with 0 prior convictions.
And oddly enough, we even have a case involving a former libertarian candidate for Congress fitting this profile. And we can see that basically this is, at least in part, it is a crime that has the purpose of going after the sons of the middle class. I mean, the sons of basically normal people. people who are not drug dealers, not illegal immigrants, and not engaged in anything except being ordinary kids or males, I guess. And of course, the phrase toxic masculinity is something that you hear also that you hear in family courts all the time. And the phrase toxic masculinity is basically about men who have normal to semi-normal heterosexual instincts, right?
Yes.
And so the again, the purposes of tearing apart the family and the purposes of tearing apart the structure of society are very consistent here, and the Constitution is, you might say, collateral damage in this. Oh, and look who's joining us. Jerry O'Neill is joining us. Jerry O'Neill, greetings and salutations. Thank you for joining us. Jerry, I can't hear you.
To have an abortion? No, she wouldn't do anything like that. She's going to have the baby and then go to a good home. How can she be sure?
Jerry, speak up. Can you hear me, Jerry?
She's going to sell her baby? She didn't think it.
Oh dear.
She's trying to do the right thing. Did she mention the name of the agency?
Jerry, I think you're on mute.
But I didn't mute him.
No.
Well, anyhow, it's good to see Jerry. Good to have him join us here. Hopefully he'll be able to effectively join us.
Jerry, can you hear us? Jerry, if you can hear us, you want to nod your head because we can't hear you. All right, you might want to check your mic and see if you've got it off because we can't hear what you're saying. Nothing.
Gran nada. Well, you know, the reason I invited Jerry to join us was because Jerry has been my inspiration for over the past 20 years in what to do with my life since I was disbarred. Jerry is one of the greatest legal minds I know, and Jerry has dedicated his entire life to attacking, and I use that word with a great deal of pride, attacking the state bar monopoly and the things that the suppression of freedom of speech and freedom of association that the Bar Association stands for and represents. And we lost him. Oh, well, maybe he'll come back. Anyhow, but no, seriously, Jerry is the man who made me feel really perversely proud of, you know, my status as an outsider, because Jerry, he's a good Christian man, a good family man. I forget how many kids he's got. He's got something like 9 kids of his own. He went through a major custody battle out in Montana and Idaho. Add to stream. Okay, Jerry. Jerry?
Still can't hear you, Jerry.
This is so bizarre. We can see you very clearly, by the way. You're definitely connected. Jerry, seriously, if Brian can connect, you can connect. Actually, if I can connect, anybody can connect. I am a neo-Luddite, as Dave Gahary was telling me. I am complete incompetent when it comes to everything technological. He looks puzzled.
Well, hopefully Jerry can join us because, like you, Charlie, you introduced me to Jerry a number of years ago. and I was highly impressed with his curricula vitae and his accomplishments in life, and I'm saying, but what happens when you take a stand and you stand up and you call into question the authenticity and the validation of those that are making the assertions against you? You are demonized and criticized, and we're supposed to all just shut up and go along to get along rather than to call it into question.
And that, again, is law and ritual. It is taboo. It is a ritual taboo to question the integrity of a judge. It is a ritual taboo to question the actions of an attorney or the legitimacy of the law. And yet, that is what America is based on. America is based on precisely those principles, that just because King George imposes a tax on us, it doesn't mean that the tax is legal or legitimate. Taking your life away is a lot more significant. Taking your son's life away is a lot more significant than demanding a couple of extra pennies on tea. Jerry, are you now? Can you still hear us, Jerry? I think he's cursing.
I don't know. We can't hear him. He's doing sign language.
But I don't understand sign language.
Right.
It's good to see you, Jerry, but this is comical. I know that Jerry has had this kind of problem in the past, but this is actually a totally different program that we're using than we ever used in the past. And Jerry's input would be very valuable here, because we are talking about precisely what Jerry's been doing his entire career, which is attacking these taboos and the political barriers that exist to common sense, logical participation in the legal system. Which I guess I would say that partly because I'm inspired by Jerry, that has become the definition of my entire life. My entire life has become the struggle for an abolition of barriers to people speaking the truth in court. And I think that best interests of the child really is one of the major obstacles that we've got. But the power of judges and the immunity that judges have to any sort of inquiry into their legitimacy, or the legitimacy of actions brought in their name. That's another one of our biggest barriers and challenges to, you keep talking about truth and justice. I don't know. I always identify with the tagline of Superman, that he fought for truth, justice, and the American way. We all need to be fighting for truth, justice, and the American way. And I can't think of a more interesting conspiracy theory, in a sense, than to allege that the government of the United States has decided to espouse this crusade against young white men, young heterosexual white men, for the sake of breaking down toxic masculinity by making false, or, if true, totally accusations of wrongdoing in totally normal sexual behavior. I think that we have to go back to the concept of hypocrisy, and how the puritanical hypocrisy that was enshrined in Nathaniel Hawthorne's book, The Scarlet Letter, has become really a means of wiping heterosexual white men off the map. These are the future fathers of America. Andrew's kids, if they remember him at all, will barely recognize him, even if he gets out this year,
Yeah.
because he hasn't seen them. And this is a tragedy. This is a tragedy, and it's only, as you have said, it's basically a self-perpetuating disaster for the country, that the family, the essence of the family, is being wiped out in this way. And that is why we have to go on the attack, because in the past 3 years, nothing has happened in your son's case, and nothing except that every couple of months they take your son in and announce to him that that his lawyer, his supposed lawyer, well, the only thing, his lawyer doesn't file motions, but what he does is he agrees to the prosecution's motion to waive speedy trial objections. Speedy
Yeah,
trial.
what my son is saying is inaccurate. He never did that. But if the attorney is speaking for you, okay, then the attorney does the talking. How does one overcome that obstacle when you're sitting there and the very party that's supposed to be combating on your behalf or fighting for you is going right along with all of the nonsense and the trickery and not acknowledging the truth? And I think that's an underpin of our judicial process, is that, and it doesn't matter whether you're in a child custody case, whether you're in a probate case, a civil case, criminal case, you hire an attorney, the attorney goes in, and then, yeah, you can go in and file a grievance, you can file complaints. Where the hell do they go? I mean, John Gentry did an excellent job of doing the historical data on the number of complaints that are filed against judges, and summarily they're dismissed 99.2% of the time, or 99.4%, whatever the hell the number was, but it was over 99% of the time summarily dismissed when it's alleged by a pro se litigant. But when you have a that pedigree behind your name, of an esquire, then somehow that gives it some validity without looking at what is the underlying issues with that attorney. And, you look at it and you see all these things, and, they got a federal judge right there in South Carolina that just got picked up on these alleged charges. But yet, he's not sitting in jail. And it's like, well, how the hell is that possible? What's the difference between my son and this individual? And then, did my son really have a nefarious attitude about this and was looking at this stuff for his own sexual gratification? Or was my son a love-struck, sick young boy that had been alienated from a father, had no idea what it's like to be a man because the system had programmed him to believe that you trust the system and, this is the way it works? And then also bearing witness to the fact that my son would sit in to these court hearings where there would be false and misleading testimony, which was proven out right there in the court, and the judge would turn a blind eye to it. He has been systematically groomed and programmed by the system that if you lie good enough and often enough, that lie will become the gospel. So they can take into court, and there's no remedy for it. And I think that is an abomination that the court has ensnared into my son's mind, or seared into his mind, that, hey, there's nothing. And I mean, because it took us 7 years to prove out all the false narratives that the court had already written. And I'm sitting and saying that was in a child custody case. Now we're not up against a bitter ex and a judge that had been previously married a number of times, had her own issues with men and things. We're talking about an entire government that can have one individual that works for them make these assertions, and then they have all the time and the money to drag it out, postpone it, prolong it, delay it, deter it, in the hopes that Andrew will adapt to the ideology that if you want to see freedom, then you just have to go along to get along. And I'm saying, Andrew, if it requires you to remain incarcerated, you don't acknowledge something if you didn't do nothing wrong. And there is nothing wrong with a 20-year-old boy, in my opinion, or 19-year-old boy at the time, engaging in a conversation, whereas a woman sends him a picture of her vagina asking if he likes it. I don't know too many 19-year-old boys that are going to say, nope, that's grotesque. They're all looking for love. They're looking for affection. They're looking for this. Lord knows, but maybe he was looking for, a soulmate. I have no idea. What I do know is that the government does not want anyone to view what is alleged to have transpired. And I just think that that's wrong. That on one hand, you can label him as a monster and a predator and all this other crap, but yet you won't tell us, how did you come to give him this label? And that was my argument when I was in court, simply because we went into court on August the 11th, 2020, and we went before one judge. I think his name was Judge Carlson, and Judge Carlson was going to have the case. He adjudicated the final day. The next day we go back, the case is thrown to a different judge, and that judge says that, and now this judge released Andrew on his own volition, allowed him to go free, and then the next morning, less than 24 hours later, after the state had given back my son all of his computers, all of this other stuff, saying that there's nothing negative or derogatory that would suggest or imply that my son has any sexual proclivities or any other nonsense, then yet within 24 hours, another judge can take and say to my son that, no, the state's already proved the burden of proof. We find that you are a serious risk, and bailiff take him into custody, bond set at $100,000. And then when you go to post the bond, they come back and say, no, there's no bond. I just find that this whole thing just reeks.
Well, okay. Now remember, we've got to do some more clarification here. What you're talking about is in 2020, this was before a state judge in the state of Illinois.
That's correct.
And basically,
and then while he was sitting in jail, Charles, now he was in jail, okay, on August, and then in November is when the FBI came in and arrested my son while he was incarcerated and transferred him up to Winnebago County Jail. Then we can look at Winnebago County Jail, which is a county jail that limits what information is disseminated because it's not a state charge or a county charge or a violation of ordinances. This is federal law, but yet my son can't get access to any law libraries or any law research in the federal realm to be able to assist him, vigorously. And I just think that, why is that? There's a reason for that.
Because there is a conspiracy to suppress constitutional rights. And as far as how to get this before the court, we know that Thomas More Leinenweber was unwilling to do it. We know that when Andrew tried with our assistance to speak up in 2021, that he was suppressed, and he was warned that he was not going to be able to represent himself in court, even though the federal law under the Feretta decision was violated. They didn't offer him a chance to even demonstrate his competence. They just warned him, "You're not going to do well." They scared him, so he accepted another lawyer, another CJA lawyer named Clarence Butler, and Clarence Butler has sat on his posterior parts and agreed to every bi-monthly waiver of speedy trial rights. And so the only way we can get into court, you and I have to file declaratory judgments, separate actions, constitutional challenges to the law. We have standing. Why do we have standing? Because in that we believe that Andrew was charged without any evidence or justification, in any factual justification. In that we believe that he was charged that way, we believe that we can be charged without any factual justification either, and that means that we have to have the right to go before the courts and demand a change in the law. They cannot prevent us from demanding our rights and comparing them to the rights that Andrew has been deprived of in these same courts. I am convinced that that is the way to that is the only path open to us, because even with millions of dollars, I mean, I'm not sure what's going to happen in the Trump indictments. I'm intent on following the Trump indictments very closely, but I mean, last night on this show, Bill Johnson, very well-established, distinguished lawyer in Los Angeles, said that he predicts Trump will be convicted, and if Trump is in no position to constitutionally defend himself, it's very peculiar. But I think that perhaps the problem is going to be that Trump is not aware of constitutional rights in the way that perhaps we are. And I think that it's only by filing these accusations in court and by doing what we can to spread them in the press, and that's part of the reason that I wanted you to be in my in the first week of my new podcast, because I want to go public with these charges against the federal government. In exact synchrony with the charges being leveled against Trump. And let me point out something: in that we are challenging the law and naming FBI agents, I predict that there is a chance. There is a chance, and I challenge the U.S. Attorney for the Northern District of Illinois, whose name is Kavitha Babu. I challenge her to seek a gag order against us from discussing this, just as they're seeking in the District of Columbia a gag order against Donald Trump for challenging the charges against him. One of my specialties is prior restraint and the suppression of freedom of speech through judicial gag orders, and I want to see them try to do that in this case, because we have a very excellent chance of being heard and getting some publicity on that point. And if we can assert our right to petition for redress of grievances, our right to challenge laws which could potentially be used against you, me, Jerry O'Neill's son, your son Zach, who was on earlier. Every man is subject. Every man is a potential subject of this kind of charges, and the agenda is exactly the same as in the family courts, to suppress toxic masculinity. And so we need to be aggressive, and we need to launch this challenge, what I'm calling a collateral attack. And I don't mean it's a physical attack. Don't worry about that. Nobody's suggesting that. But I think that's our only hope. That's our only route, is by saying, basically, as long as some people are subject to prosecution without due process of law, all people are subject to prosecution without due process of law. And so that is my you're looking very tired, Brian. Are you okay?
Oh yeah, yeah, I'm okay. I'm just tired, frustrated. Charles. As you said, it's been 15 years, and it's like you never really get out of the battlefield. You just change locations. You go from one battle to another. When I got my children back, I thought, wow, now we have a chance. But the children had been so severely alienated in 7 years that the role of the father had been marginalized to where you're just nothing more than a mere Disneyland dad, And I think that there's a lot of negativity that the court caused and a lot of um, alterations in my children's minds, that they never want to give an account for. The court don't, okay? I'm sitting and I'm saying, how is it possible that we can live in the United States of America, the land of the free, and yet allow these people to be incarcerated? It's no different than back in the day. They used to take and send African American people to the back of the bus because it was the law, Charles. And then you had one little old lady that was worn out, tired, fed up, and disgusted because she's been lost in her house, working, cleaning toilets and everything else for a bunch of rich white people, refusing to move to the back of the bus. And it brought about the change to see the violations that was occurring. That this isn't right. This isn't how we treat our fellow man and our fellow human beings. But yet the court system, all they see is money and potential for money. There's a reason why the United States leads the world in incarceration. And yet we make a profession that we are the greatest nation in the world. And yet I'm questioning how accurate that statement is, given that we can look at the literacy programs and the problems that we have there. We can look at the high school dropout rates, teenage pregnancies, compare it to the next 5 highest populated countries, and we lead the way in all of these areas, and yet we have a system that's designed to ensure the best interests of the children, and yet our children are the ones that suffer the most. I think
that phrase, best interest of the child, and that is just something Jerry and I Jerry, have you resolved anything yet? Guess not. Anyhow, Jerry and I have discussed best interest of the child. Basically, that phrase is such a red herring because to the degree that the best interest of the child is an ideal, okay, that's great. Yes, all of us want what's best for children, but
who gets to make that determination, Charles?
Well, listen to me. It's too vague.
I mean, one of the things, Charles, if I could just interrupt, I mean, when I was going through my child custody case, they kept on talking this minutia about, the best interest of the child, the best interest of the child. So let me understand this. If I make an arbitrary election of choice because he's failing school, okay, and I say, nope, you're not going out. You're not going to hang with your friends. You're going to study. We're going to get through this thing so that you can have further your education. What right does the court have to come along and say that we are damaging the child based because we won't allow them to have social interaction or entertainment by going with their friends bowling and things? It's like, this is just nonsense. So now we've positioned the court to make a determination, stepping in as parentia pyra, as the parent in fact. So now you get to dictate what God gave me, and then you believe that your rights or your belief, and just as it is with the Jeff Younger case down there in Texas, so you have a woman that tells her 7-year-old son that he's a girl, sends him to school as a girl, dresses him as a girl, changes his name to Lula, and everybody else adapts to this ideology, and a judge says, yep, this is a girl, even though he was born a boy, and yet that's okay because it's social engineering. We want everybody to be dependent upon whatever the judge says. Well, what if the judge says, hey, I think it's in the best interest, Charles, that you never see your child again? Well, that's your opinion, but unless you have concrete evidence that I somehow possess a risk, a danger, or a threat to my children, you can't take something that God's ordained. They are my children. They're not yours. But the court wants those children because they make a profit off of those children.
Well, what's more, not only do they make a profit off the children, but they have eternal power if they control the lives of our children. They have power over the future. Again, we see this consistency in in from one charge to another, from one case to another. You're talking about the Jeff Younger case in Texas. Again, that's an attack on so-called toxic masculinity, on the future fathers of America. That the future fathers of America need to become infertile women, because that is in effect in the best interest of society, if the goal is to suppress freedom completely and turn us all into robots. And I think that is what I sincerely see, is that there is a goal of suppressing the individual, suppressing the natural order of freedom. And when you're talking about which rights come first, you're asking a very interesting question. But of course, the Constitution of the United States has this hierarchy of rights embodied in the Bill of Rights. And the very first among those rights is the freedom of religion, and the freedom of religion, followed by the freedom of speech and the right to assemble. Those are the heart of the family, are they not? I mean, our belief that a man is real because Adam was real, Eve was real, and that is the template for society. And if you abolish, I mean, if you see, that's part of the best interest of the child, the whole conundrum of the best interest of the child. They can abolish that. They can abolish the presumption of sexual identity. You were mentioning that in the Younger case, Young, is that his name? Younger?
Yeah, Jeff Younger.
Jeff Younger, you were mentioning that a kid can elect a sex change. How about the question of Jerry is a former member of the legislature of Montana, with one of the top right to life ratings in the country, the highest possible. And what about the fact that that same 12 or 13-year-old girl has a right, or until in many states, in Illinois, for example, still does have a right to go in and get an abortion. What is the meaning of that? I mean, that's not just mutilating her own body. That's potentially that's preventing another life from coming into existence. It's and it has and the consequences of abortion again are the suppression of the family, the suppression of the succession of population. And
But do
that,
you see the hypocrisy in that, Charles? I mean, here you have in Illinois where this alleged incident is alleged to have occurred. And, here you have a 12-year-old or 13-year-old that can go in and have an abortion, which means that she actually engaged in, sexual relations. And, there's no ramifications there, right? That's condoned, that's accepted. But a young man that wants to take and say, oh, yeah, I'd like to entertain the thought of you and I, becoming a couple, or, maybe having children down the road. And you're not talking 12 or 13-year-old, but a 16-year-old that, does this. And yet that somehow my son is a monster because he acted upon his God-given impulses to engage in a conversation that may have been may or may not, because we don't even know, because we can't see any of the information that's being brought up against him. And I'm saying that, in my opinion, the secrecy is what scares the hell out of me.
well, I mean, but that goes back to the hierarchy of rights I was talking about. And it looks like Jerry gave up. The hierarchy of rights I was talking about is, the Bill of Rights says that the right to confront witnesses and to see the witnesses, to see the evidence against you, is one of the basic rights of a free person. And I don't see any way around it. I think that there is a great deal of responsibility involved in bringing charges against somebody that could result in a 15th or 30-year incarceration, even a 3-year incarceration. That is a very important responsibility. And I think that teenage girls are absolutely positively competent to understand the difference between right and wrong, and to say either yes, I was involuntarily dragged into this exchange, I was forced or paid, as as you said at the beginning, the official charge against your son is that he bought and paid a child, bought and sold children. It's ludicrous based on anything we actually have evidence of. But a child who was actually captured, there have been children in history, in Africa and in Europe for that matter, who have been captured, kidnapped, and taken into slavery. We know that. Slavery was real. Kidnapping children is a real aspect of slavery. And so if it really happened, the child does know that it happened, and the child can say, yes, that person there put manacles on me and took me into slavery and then sold me, say, at the Algiers slave market, where a lot of European children were in fact sold into slavery in Africa. It's very well documented. And yet, the idea that she could also say, oh, are you kidding? I was flirting with him. He had a really cute picture online, and I wanted to fantasize about us hooking up together, and so I sent him pictures of myself. You know, I sent him naked pictures of myself, and I did so voluntarily. And if a jury hears that line, what are they going to do? If the jury hears, oh, I totally did it of my own volition, that's going to be a very different reaction to he paid me, he coerced me, or he actually physically took away my free will. Those are three real possible stories that could happen. And in our American system, Andrew is entitled to hear what she has to say, and so is a jury. And the fact and to allege that you have to protect her right to make false accusations, this is just absurd. Everyone, she is entitled to accuse Andrew of actual rape. But if she wants to, if a girl actually wants to make such allegations, she should be responsible for lying if she's lying. And that's
Charles,
just,
one of the things
that's
that I
our
want,
life.
one of the things, Charles, that I wanted to illuminate too is that, and you can type it in. I think the girl was 11 years of age, but when she was 8, she was accused of murder. Okay, she's the youngest.
I can barely hear you. You said an 8-year-old was accused of
Yes,
murder.
yes, she was accused of murder, and then they were
You know.
saying there's no way this innocent girl could have done this and things. And anyway, she's the youngest convicted felon, female felon, and her name escapes me, but she had went on and she murdered 3 boys before she was 11 years of age. Now, where was the? So I'm saying, wait a minute. Simply predicated upon somebody's gender, we give the appearance that, hey, this couldn't be or that couldn't be. And I'm sitting there calling into question, does or does not Andrew have the right to subpoena all of this alleged minor age, her emails, her text messages, her Snapchat, everything like that, to see if she's engaged in other conversations, because she might get her jollies off because I have a personal vendetta against men and I just want to see every one of them incarcerated. But all I have to do is set the stage and the government's going to come in and get the rest, if minor A even exists. And that's what we have with the government. They create this fictitious person and there's no way to validate it. And I'm calling into question, should or should not my son have the right to call into question all of this information?
Okay, until 2251, 2252 were passed, he did without question. And under these statutes, basically, Congress has suppressed freedom. And we need to have a judicial and a public and fully political discussion of whether this is proper or not. And again, I think that goes back to knowing the difference between right and wrong and being able to take responsibility for your actions. Because if what you, I mean, right now, we know that the jury is never going to get to hear her say that if that's what she felt, because it would discourage her from making charges in the future if we compelled her to say that now, because then she'd have to take responsibility for it. This is it's the point is that the courts are using the protection of children to turn society upside down and
Yes.
to turn the Constitution upside down,
Yes.
and we have to fight that. And if it could happen to Andrew, it can happen to you, it can happen to me, it can happen to Jerry, it can happen to any man. Apparently, 94. It could happen to 94% of white men in the United States.
Yeah.
And
So, and then that calls into another question. I mean, is this social profiling by the FBI? Because, hey, we've already set the stage and put this mundane crap out there, like, oh, if you're an African American and you come from poverty, then you're probably selling dope or something like that if you reach a level of success. And they have these stigmas and these associations simply predicated upon the color of your skin or your economical status. And yet we see like all of this stuff here, and the Department of Justice right now, to the levels that they went to conceal what was happening in Hunter Biden's case. But without an arsenal of economics and great legal minds, okay, this stuff just continually transpires and it repeats itself over and over and over, because the legal system knows that it is a matter of economics, and that economics plays out in time and the ability to do the research. And, when I was saying earlier about Andrew being his own best defense, Andrew's best defense, though, is to listen to common sense and rationale and logic. But I'm saying, Andrew, you was there. I wasn't. I don't know. But I'm saying that if somebody's going to bring forth a charge saying that I've done this or I've done that, then they need to produce the evidence, not just base it off of mere hearsay, off of an FBI report that's supposed to be accompanied by an affidavit from this alleged minor A that's nowhere in the record, and that my son doesn't have the right to be able to view this stuff. This is just an absolute nightmare.
it is. It is. And the really nightmarish part of it, as you say, is that if the FBI can go around collecting or inventing stories like this, none of us are safe.
Yeah.
None of us are even remotely safe, because if I go back to my example of saying, Brian, I believe you did. I know, not I believe, I know that you betrayed your country by making a private deal with the Martians, and you've made sure that there are Martians living in your houses in Springfield, Ohio, and that Martian colony in Springfield, Ohio, is going to be the base for an invasion of the world.
Yeah.
Hey, I mean, if you can allege one thing, you can allege the other.
Yeah.
And I mean, if I'm Michael Barker and I don't have to produce the Martians, and I don't have to say which addresses you're letting out to Martians, then basically I'll tell you what that gives. That would give, I guess, the courts a right to seize all of your houses in southwestern Ohio, and say we're seizing his houses because based on an FBI investigation, we know that they're being used by alien invaders.
Yeah.
I mean, that is the kind of logic we're dealing with. And that is the challenge that we're facing, is that if you can say one thing, you can say the other. And if the Constitution means absolutely nothing when it comes to lurid stories about or potentially by teenage girls. If it, I mean, you know, other than food and sleep, the third most important need that most humans have would then be sex. And if you can break that barrier, uh, and say that wanting the third most common human need is a crime, and basically that every male who uses a smartphone is responsible for going through an elaborate verification process of the identity and age of any person he wants to sext with. This is insane. This is a world. It's not just insane. It's a world where all of us can be prosecuted and charged at all times, and the concept of freedom is gone. It's over. And I think that is really more than any other single reason why I I have stuck with you all these years, and why I think it is so important that we, now that Andrew's case is set for trial in 2 months. In 2 months, your son is due to go for final trial. Now, whether they'll keep continuing it, I mean, maybe they want to keep waiving speedy trial, and maybe they'll continue this again. But last year he was set for trial in September, and when he wouldn't take a plea deal, or when he was unwilling to plead guilty, they gave him this 1 year continuance that nobody asked for.
14 months.
You're
14 months. They gave him
Okay.
14-month continuance.
Yes, that nobody asked for. Certainly, Andrew didn't ask for it.
Yeah.
I mean, who knows? I don't know if they'll do that again, but right now there's no plan to put evidence on, or I don't even know how a defense attorney would cross-examine an FBI agent who has the right to say, I have to protect my sources. I mean, protection of sources is usually part of freedom of the press, because the press wants to be able to accuse the government of wrongdoing without subjecting, whistleblowers to government prosecution. You're getting. I can't hear you again.
Okay, because the government wants to take and, the press, they want to try to salvage their sources, whereas now it's been a flip side, and the government wants to persecute and prosecute people simply based off of their belief. No facts, no findings, no evidence, just based, well, I'm an FBI agent and this guy works in a damn factory. I mean, who are you going to believe?
Well, I mean, the way you're supposed to be able to handle it is, well, sir, you're an FBI agent. That's wonderful. Did you observe Mr. Bolts? Did you observe his actions? Did you see him doing this? No. Do you have a recording of his voice? Or do you have can you authenticate a transcript? And if so, how? How would you authenticate a transcript off his cell phone? I guess you'd have to get T-Mobile or whatever his provider was to certify this is the tape, and then so you'd have to bring in witnesses. Have they disclosed any witnesses? No. To the best of my knowledge, they haven't even sought a list of witnesses who would be called. We need to demand the witness list. Who from the phone company is going to authenticate any of this stuff? It is our right to challenge, and if we don't do it, nobody's going to do it. And your son and thousands of other men like him are just going to be thrown away. And I can't hear you.
When you've been beat.
Okay, I can't hear a word you're saying.
Can you hear me now?
No.
Okay.
Now I can.
Okay. And I say, Charles, though, what happens, though, is that the court system beats you down emotionally, mentally, spiritually and financially. So once as you're bankrupt, okay, how the hell do you go forward with, putting forth the evidence without economics? And that's what the system plays off of. If you don't have the economics to get this information in, to be able to get it in front of
You're
people,
fading out again.
I don't know, Charlie. My phone's about to die, but I'm saying that.
Yeah, it's really bad. I'm only aware that you're speaking right now. I can't hear anything you're saying.
Okay, well, I don't know. My phone is about to die.
Oh my God. Well, anyhow, we're nearing the end of our hour. We've got about 2 hours actually. We've got about 10 or 12 minutes left. But can you get back in, or you can't?
I've done nothing to the phone, Charles.
Okay,
absolutely nothing.
Okay, well, you're fine now.
Okay. Well, like I said, is that it all comes down to economics. The government has more money than what any one of us will have, and they can create it out of thin air. Okay. And they know that without economics and without a good legal strategy and a legal defense team, not an isolated individual crying in the wilderness, that the possibility and probability of getting heard is thin to none. So without money, nothing changes.
I mean, the interesting thing about what you're saying is, of course, the government is providing, quote unquote, a free defense for Andrew right now, which constitutes no defense at all.
Right.
That is the worst of it. There is money available to be paying a lawyer, but apparently he is under orders to make sure that Andrew Bolts pleads guilty.
Yep.
And this is the ultimate sarcasm and the ultimate abuse of the system. And it has to do, again, with power based on ritual separation and the idea that you and I simply lack any capacity to ask reasonable questions or make reasonable challenges. And more than anything else, I think that's what we need to stand for here. That the people of the United States, ordinary people without titles, without membership in the peerage that is either the state or federal judiciary or their appointed agents, lawyers. Every person has a potentially valid voice and opinion, and the Constitution should exist to protect every person's voice and opinion, and it should not exist to be beating people down. And everything you say is absolutely true. And it's inexcusable that in this country something like this could ever happen. And that is the essence, again, of my crusade, and I think your crusade, to assert our rights and to demand that our voices be heard. And this podcast is planned and is going to be the platform at which I urge people who are victims of the system to come forward and start speaking out. And we need to find ways and means of speaking out, tearing the power away from judges, tearing the immunity away from judges and lawyers, tearing the veil of secrecy away from FBI agents and other law enforcement. The federal government has the power to destroy the world. This is the month of August, when 78 years ago, we unleashed the atom bomb and showed that our government has the power one city at a time, one region at a time, to wipe out the world. Any government that has that kind of power has a duty to hear the voices of individuals who might be snuffed out. That, I think, is the most important thing you and I have to work for right now, is to make sure that the human individuals retain and enhance their ability to speak loudly, and at least as loudly as the government. Some people say that the purpose of the Second Amendment was to keep the people armed against governmental intrusion. But the First Amendment is even more important. We must speak out against the government's irrationality and vicious suppression of our rights.
But one of the problems there, Charles, is that, and this is one of the things that I struggle with. You know, for 7 years, I often question, what's the point in me speaking out if it falls on deaf ears? And we have to have a direct line to Congress, to our House of Representatives. We have to be represented, and we have to be able to look at and present the evidence that we've gained and we've gathered over the years to solidify our belief that the entire judiciary has been weaponized against the American people. That you either go along with what they say, simply predicated upon the pedigree and their status as a judge, whereas we can look at Judge Civarello's case, Judge Monahan's case, and these people here, while they got indicted, they never paid for the crimes that they committed to the victims' families. They had to pay because they were caught by another corrupt organization, the FBI, by the IRS, for not paying their fair share, their portions of their spoils over to the IRS. So there was never really any justice for those children that was put into that juvenile detention facility illegally. Even though they released all of those juveniles, they never got compensated for the illegal incarceration. And I just find this an abomination.
Well, how would you step by step change it? What would be the
Well, I
first?
think the first thing that has to be removed is we have to have accountability of and from the judiciary. How can a judge take and deliver justice if they're not willing to step to the same yardstick and be measured by their own fruits, by their own works? But yet a judge, they can act wantonly, maliciously, knowingly, intentionally violate your rights, and yet they are immune from liability simply predicated upon their position. And it's like, this is insanity. How can you sit there and knowingly go along with a charade simply because you can, and there's no recourse for the people to speak out because it's falling on deaf ears? Because and just as John Gentry's findings have found, that he took to the state of Tennessee and right on up through to Congress, whereas the people are summarily dismissed and denied, simply predicated on the illusion that these are just pro se litigants that are upset or disappointed with the decisions of the court. That's inaccurate. They're disappointed that there was no facts or evidence for the judge to reach the conclusion in which they did, and yet we have like a fellow down in Texas there, and his name escapes me, spent 40 years in prison for a crime that he didn't commit. No brothers, no sisters. His mother's dead. His father's dead when he gets out. Finds a letter that was by his father 20 years prior to his release, stating that the greatest regret that he had was that he could never make enough money to hire a good legal defense firm. And it's like, to me, it doesn't matter how much money you spend, that the system, unless there's going to be mechanisms in place to ensure that that which is guaranteed is actually delivered, it's all for naught. We talk about the guarantees of the Constitution. We talk about the guarantees under the Bill of Rights. We talk about all these guarantees, but where's the practical application to ensure that we are getting that which is a guarantee?
The only thing anyone can say is that every person who has an interest, whether it's a father or
Grandfather?
a legal activist, stand up with the people who are actually behind bars in the system. We have to take social responsibility for fixing what appears to be broken. If we don't take collective responsibility, then for fixing the problem, then we are collectively responsible for the perpetuation of the problem.
Amen.
That would be my answer. We cannot stand by. We cannot stand by and watch injustice accumulate and accumulate and accumulate. I mean, I hope that the Trump indictments are going to wake up some people who are currently asleep right now. But I think that we are so conditioned by the past 30 years or more of garbage justice that everybody is exposed to. We saw in the Clinton administration, we saw the Republicans cynically trying to take down the president for maybe getting a blowjob from an intern while he was in the Oval Office. Wow. I mean, can we, the whole world was laughing at us, and yet the American people stood by and just let it happen.
Yeah.
And that set a pretty awful precedent in and of itself. And I mean, the interesting thing, well, looks like we're out of time. Brian, thank you for joining me. You look very tired. We'll have to continue this conversation. Thank you very much. I'll be on every Tuesday and Wednesday from here on.